So, Chapter 14 talks about intellectual property and laws that protect property that is primarily the result of mental creativity rather than physical effort. Talks about a trademark, which is distinctive mark, word, design, picture, arrangement used by the producer. Goes on to talk about a trade dress, which is the overall appearance and image of a product that has acquired secondary meaning. Talks about the Federal Trademark Dilution Act of 1995, which provided trademark protection at the federal level. Talks about a patent, which grants the holder the exclusive right to produce, sell, and use a product, process, invention, machine, or asexually reproduced plant for 20 years. Talks about obtaining a patent, and goes on to talk about a trade secret, which is a process, product, method of operation, or compilation of information used in a business unknown to the public. It talks about copyrights, which is exclusive legal right to reproduce, publish, and sell a fixed form of an expression of an original creative idea. And the criteria for a copyright is fixed form, original, and that it's creative. Talks about the fair use doctrine, which provides that a portion of a copyrighted work may be reproduced for purposes of criticism, comment, news reporting, teaching, scholarships, and research. And then we go into Chapter 15, which talks about agency, which is fiduciary relationship between two persons of which one, the agent, acts on behalf of and is subject to the control of the other. Talks about employer and employee relationship, which is an agent who works for a pay and is subject to the control of the principal. May either into contractual relationships on the latter behalf. Talks about the creation of an agency relationship, express agency, implied authority, ratification of the agent's previous acts by the principal and the parent agency. Talks about agency by ratification, which occurs when a person misrepresents himself or herself as an agent, and the principal accepts the unauthorized act. Talks about estoppel, I think that's how you say it. It's a legal bar to either alleging or denying a fact because of one's previous words or actions to the contrary. Talks about contractual liability, talks about some cases, e-commerce, which is intelligent agents, click-on agreements are being developed for online stores that are more easily understood by e-agents. Talks about disclosed principal and partially disclosed principal, undisclosed principal. And then goes into talk about tort liability, which is liability is decided by checking whether tort was committed within or outside the scope of the agent's employment. And criminal liability, which is principals are not liable for criminal acts of their agents except when the principal participates directly or has reason to know that a violation of law by employees or agents is taking place.